Good morning, everybody. This is the Colorado Oil and Gas Conservation Commission. This is our weekly meeting. It is Wednesday, December 8th. It is 9 o'clock. We will start with a roll call.
Thank you, Mr. Chair. Commissioner Bogue.
Here.
Commissioner Gonzalez.
Here.
Commissioner Hackett.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa. Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present.
Excellent. Thank you, Ms. Larson. Good to see everybody. Hope everybody's doing well. We will move forward with our agenda. We start with commissioner comments. If commissioners have things that they would like to inform the rest of us about, I can start since I'm talking already. We want to acknowledge the good work of staff in the financial assurances rulemaking. Late last night, the December 7th draft was published. Would note for everyone that we are still technically working to get that up on our website. It is in the e-filing system, so folks can go out there and find it. Couple of comments about the financial assurances rulemaking. We have 103 parties. That's not 103 individuals, that's 103 different groups of folks that are interested in this matter. We appreciate the interest in the work that we're doing on this very important topic. Some upcoming dates, the responses to the 12-7 draft are due on January 7th. Pre-filed testimony is due January 12th. Rebuttal to the responses is due January 17th, and we start hearings on January 20th. So we look forward to everyone's work on that matter. I just want to suggest or speak a little bit generically around the financial assurances rules. I've taken a quick look, and I want to note that the new rules reflect feedback from a diverse set of stakeholders. Really appreciate the collaborative work that has gone into getting us to where we are now with this iteration. I would note that the rules are iterative and reflect the stakeholder feedback, and they definitely reflect the interrelationship of different facets of a very complex and varied industry. And one thing that I note as I've been looking at the rules as they have moved around and as we've listened to stakeholders about it is that there are definitely intended and unintended consequences that cascade through the rule provisions. So when you do one thing here, you have a reflection over here. And I would just want everyone to understand that and to remain engaged with us. This is yet another iteration of some ideas, and we look forward to the next steps in terms of hearing feedback and continuing the dialogue with commissioners, with each other, with stakeholders. That's all really important, and we look forward to getting ourselves to rulemaking hearings in January. So with that, again, I really commend staff for listening to everyone as we've gone about this rulemaking, which is complex. And I do believe that at the end of the day, we'll get to the spot that is the right spot for Colorado. So thanks everybody for all the hard work on that front. Any other commissioners with comments? Commissioner Hackett?
Thank you, Chair Robbins. Just a reminder, next week is the big Air Quality Control Commission oil and gas rulemaking. I believe it'll be public comment session starting on the 14th, and the hearing should go all the way through next Friday. One thing that the Air Division is interested in doing, if COGCC is open to it, and I'll work with Hearings Manager Larson on this if there might be an opening, we'd like to give commissioners an update on the rules that the Air Commission might potentially adopt next week. So if there's an opportunity in early January or sometime before we're really involved in the financial assurance process, we'd like to give that overview presentation if you're open to it. Another thing I wanted to flag for people is staff in the Air Division is working on public comments to EPA's proposed rule to further reduce emissions from the oil and gas sector. The long word for the rule, or the name of it, is Standards of Performance for New, Reconstructed, and Modified Sources and Emissions Guidelines for Existing Sources in the Oil and Gas Sector. We're hoping to finalize some internal comments by the end of this year, and we'd want to give COGCC an opportunity to review those comments and see if there might be an interest in signing on to the comments the Air Division will be submitting. So more to come on that, and thanks for the opportunity to provide those comments.
Thank you, Commissioner Hackett. Yeah, I think that the Commission would love to get an update about the Aqcc rules that are generated as a result of next week's hearing. We'll look forward to listening in. As I mentioned, we start our rulemaking on January 20th. If there's a short opportunity ahead of that, that would potentially be great. Otherwise, we probably could have an update after February 7th when we conclude the financial assurances rulemaking. All right, other commissioners with comments? All right, seeing none, we will move to general public comment. We had 2 folks sign up today for general public comment. I would note for the record that we received written public comment from Janice Brown. I appreciate Ms. Brown's written public comment. Would call upon Marie Venner and then Maya Benveno, and I apologize if I destroyed that last name, but those are the 2 folks that signed up for public comment. Each of you will have 3 minutes. We've got a timer up on the screen so that you can see that. And so with that, we would look to hear from Ms. Venner.
Before I start, I'd like to tell the commissioners that in order to do the timed comments, many of us are reading something, which means we're not watching a timer, like we're reading a piece of paper or something on the screen. So just so you're aware of that, but this should be just about 3 minutes. Good morning, commissioners. As I think you have seen, many members of the public have lost hope in this process and any sort of democratic input and sense that the law is being followed. The rules you have drafted seem to only attend to the 1% and less, those drilling, as if the laws passed in 2019 do not exist. The Commission and staff are only listening to those being paid hundreds of dollars an hour to advance their private interests, regardless of the public harms or the law. It is a peculiar interpretation that the law does not apply or you only follow regulations. I have a background in administrative law. In fact, the law remains central and governing no matter what. Regulations have to follow the law. Thus far, decisions are not protecting the public or elevating this as required by the laws passed in 2019 over oil and gas drilling claims and preferences. It is like 181 and 1261 do not exist. At this point, you have heard from many Coloradans across the broad spectrum of those of us who I would say are in the 90%. Colorado small businesses and their associations, rural and urban community organizations, people of faith, their congregations, leadership in organizations, political and community leaders such as City Commissioner Christy Douglas from Commerce City, and neighborhood organizations, regional and statewide groups in organizations representing the people at large, representatives from NAACP, Colorado Latino Forum, women's groups, mothers groups, doctors, educators, researchers, children, even teens, those in their 20s, those who are disabled. Many of the above made a huge effort to become part of the party process this time and get you comments after your straw dog proposal and before the next draft, only to see all of that input at high effort utterly ignored in your next draft. Do you need this submitted again? I can't tell you how anti-democratic and devastating this is to groups encouraged to participate and told that Coloradans and the law matters when they are so easily and completely discarded. I am here today to tell you that you need to fix this, not ignore this. This is not a minor matter. With your financial assurances rulemaking, you have an obligation not to impose the shutdown and remediation costs of this 1% industry on the public, along with their other health impacts and costs, including devastation of core Colorado industries in our state, depending on climate, adequate moisture, clean air, and quality of life. Again, the law is being ignored in disregard to, again, privilege exactly those who prefer to have the rest of us, business owners and community members who follow the law and pay taxes, pay their tab, and have you shoot us in the feet at the same time. We also have recommendations for future presentations. We'll submit that separately since I'm out of time. Thank you.
Thank you, Ms. Spinner. I disagree with almost everything you just said. Our commission is listening to everyone.
We have evidence to the
Ms. Spinner, I have the floor now. Thank you. We are not listening to 1%. We are listening to everyone. We have engaged a stakeholder process that is voluminous. We have increased standing. We are abiding by 181. We have created robust regulations, and everything we're doing is consistent with the authority that we are following. So I'm sorry if you disagree. We appreciate your public comment, but I just want to reflect the record that this commission believes that it is doing what it is supposed to be doing under the law. We now will hear from Maya Benveno.
And Mr. Chair, I'm looking for Maya. I'm not finding her at the moment. And Ms. Amaro, please correct me if you see her, but I'm not seeing her right now.
Okay. Well, let's keep looking for her.
Okay.
And I'm looking as well. And I'm not seeing her either. And that was the last person that signed up for public comment, correct?
That is correct.
Okay. Why don't we move forward with our agenda? I know that next we had a staff presentation from Gordon Pierce with the Air Pollution Control Division. And I know that we needed to give him kind of a heads up, so I'm not sure if he's ready yet either.
He should, Mr. Pierce should be joining us in a minute or two. We alerted him that we were running a...
Hey, Ms. Larson, I see someone named Maya.
Oh.
And maybe that's a public commenter?
Yes.
Hey, Maya, can you hear us? You seem to still be muted.
Hello?
Hey, I don't know how to pronounce your last name, but hopefully you're the correct Maya that signed up for public comment. We look forward to hearing from you.
Yes, I'm Maya Bovino. Are you ready? I'm sorry for being a little bit late. I was up at
No
resort.
problem. I see that you're in a car and we appreciate you taking the time to be with us today. We've got you set up for 3 minutes and you're just ready to go whenever you're ready.
Okay, perfect. Thank you so much. Hi, like I said, my name is Maya. I'm 18 years old, and I live in Nederland, Colorado. I just wanted to start by saying that we're on the ancestral lands of the Ute, Arapaho, and Cheyenne, along with 48 and more other tribes that maintain the land we now call Colorado for thousands of years prior to the European settlement, which inhumanely removed Native Americans through manipulation, disease, and violence. Today, Indigenous people, along with the Black and Latinx populations of Colorado, continue to live with injustice as they are disproportionately impacted by adverse impacts of oil and gas extraction, an issue that is the direct result of the permitting that you are in charge of on this commission. So thank you for listening to me today. I really appreciate the time. And I just want to share a little bit about other public comment hearings that I've been to recently. So last Thursday, I went to there were over 100 members of the public who showed up to give public comment. Through almost 4 hours of public comment, where only one person spoke in favor of Xcel's plan, it became blaringly clear that the continued production of energy off of oil and gas hurts Colorado citizens in countless ways. Real people are faced with health impacts, cancers, asthma, birth defects due to the toxins and particulates emitted into the air, and the impact of climate change is actively destroying Coloradans' way of life, be it through deadly wildfires, dangerous droughts, and this season, the stark lack of snow. For example, at Eldora, the ski resort 30 minutes from my home and where I'm just coming from right now, 2 prominent and well-loved community members have died in the past 2 weeks due to accidents caused by poor snow conditions. Just yesterday, 2 young kids who my family know well lost their father. People are just trying to do what they love, and climate change is threatening that every day. While listening to the 4 hours of public comment, I couldn't help but think, how many stories of despair do commissioners need to hear before they address the issue at the root and stop permitting industries to profit off the detriment of humanity? How many comments do you need to hear before you say no to the next fracking permit? Additionally, it is absurd to make Coloradans pay to clean up the mess left by the oil and gas industry's fracking projects. I demand the COGCC require a bonding of $270,000 per well, which is only the average cost to clean up abandoned wells, and abolish the absurd $100,000 blanket bond. At a point when renewable energy is cheaper and cleaner than fossil fuel industry or fossil fuel energy, fracking truly only hurts Colorado citizens. The oil and gas industry should be responsible for the cleanup and capping of orphaned wells, not us. I'm currently working on a project to organize ways for youth to get involved in climate action to help address the immense anxiety and hopelessness many members of my generation are facing. Though I would love to empower them to share their voices at the COGCC hearings, my fellow organizers expressed concern that this would only add to the feeling of helplessness, as no matter how many times we show up and speak, no matter how many stories we share, no matter how hard we ask you to open your hearts and use the law and your position to act boldly to stop fossil fuel extraction, you still continue to permit new fracking wells. I ask you to reflect on why for a moment.
Ms. Bienvenue, forgive me, your time has expired, just so you know.
Okay, sorry about that. I'll make it quick, but please do reflect on how it is your role to determine whether these fracking permits are accepted or not. And I'll just leave you with this final thought. Please stand up for humanity, stand up for yourselves, for your children, and use the law to say no to the next permit. Thank you.
Thank you, Ms. Benveno. Appreciate your being with us this morning. Ms. Larson, does that conclude public comment?
It does, Mr. Chair, yes.
Mr. Chair, if I can make a quick point of clarification.
Go ahead.
I did just want to say I appreciate the public comments this morning, but wanted to mention the most recent comments about the 4-hour meeting this weekend. That was an Air Commission meeting, not a COGCC meeting, but still, point well taken. Our agencies do work very closely together, and we have a shared mission to protect public health and the environment and minimize emissions. But just wanted to make clear that that I think was referring to the Air Commission hearing or meeting that occurred this weekend.
Yes,
thank you for the clarification, Mr. Hackett. All right, I see that we have Mr. Pierce is with us. So if we want to bring him to the panel, we will move to our next presentation, which is a presentation on ambient air quality standard attainment, trends and contributions from oil and gas operations.
There you go. Thank you. I don't know, did you want me to run the presentation or did you want to, Angelica? Or?
Mr. Pierce, we can certainly do it from our end if that's more convenient for you. Just give us a moment. It's entirely up to you.
Yeah, I can do it. That's fine.
Okay. Thank you.
Sure.
Great. Thank you, Mr. Pierce, for being with us. We'll let you share screen.
Okay. Hopefully you can see that in full screen mode at the moment.
Yes, we can see it. Thank you.
Okay. So thank you for the opportunity to provide a presentation today. So this is a similar presentation to what was provided to the Air Quality Control Commission a couple of months ago, but just an overview of our summer ozone season, where we stand on ozone, and how things, what are sort of plans with the Regional Air Quality Council. So to start out, ozone is one of the 6 criteria pollutants that EPA has established that have national ambient air quality standards that are health-based standards. Currently for ozone, we have been falling underneath at least until a few years ago, the 2008 standard, which is set at 0.075 ppm or 75 ppb parts per billion. And then in 2015, they established a new lower standard of 70 parts per billion. Historically, what EPA has done is when a new standard comes into effect, they have eliminated the old standard. Unfortunately, in this case, there were a number of court challenges looking at, people were concerned as far as backsliding. So EPA never did eliminate the old standard, so we actually have to operate under both standards. This doesn't, obviously, the newer standard is more stringent, and that's the one that's going to come into play when we're looking at attainment. But where it does come into play is when we have to look at developing our state implementation plans. And so at this point, we have to develop state implementation plans for both standards. So both standards are defined as the 3-year average of the daily fourth maximum 8-hour values. So you take the fourth maximum value from 3 subsequent years and average those together. If it's over the level of the standard, then you are not meeting not meeting the standard. So they do allow for a number of exceedances each year without actually having a problem with actually exceeding the standard. Ozone is mainly a health with health effects is an inhalation issue as far as irritating the airways and reducing lung function. So it does aggravate people that have chronic lung disease. So those with asthma and emphysema are certainly have much more susceptibility to health effects from high ozone levels. It can increase the risk of premature death for those that have heart and lung disease. And so those, children, those that breathe heavier, such as people that are active outside, are ones that are going to be impacted more significantly as well. Ozone is a little more difficult to control than a lot of the pollutants that we deal with, in that it's not directly emitted, but it's a secondarily formed pollutant. And that is, it doesn't come out, for instance, just straight from a tailpipe or from a smokestack. You need essentially a chemical reaction that goes on, complex reaction between volatile organic compounds and nitrogen oxides in the presence of sunlight to form ozone. VOCs and NOx both are emitted from combustion sources, so from vehicle emissions, from other engines, and then VOCs are obviously emitted from oil and gas sources as well. So it's not a linear relationship, so it can be a case where you can decrease one of these 2 precursor sets of compounds, and you can actually get an increase in ozone concentrations, just the way the chemistry works. And so that does make it very difficult to control. With it being related to sunlight, the highest concentrations occur in the summer. And just the way that the meteorology works in the Denver area, we typically get the highest levels because of upslope conditions. We get the highest levels along the foothills. We can also get wintertime ozone. It doesn't happen often here in Colorado. It's certainly been noted in some other oil and gas basins, the Upper Green River Basin in Wyoming and the Uinta Basin in Utah, which does come somewhat into Colorado. And it's when there's a deep inversion and when the snow covers. So you effectively get the sunlight reflecting off the snow and doubling the effective albedo of the sun to create the chemical reactions. The other big source of the OCs that we do have is biogenics from vegetation. So starting out with more of the kind of the cleaner areas of Colorado as far as what our ozone levels. So starting out with Southwest Colorado, and this does include the San Juan Basin. A lot of the production, oil and gas production down in that area is on tribal lands, but as well as in New Mexico. But there is some production on state lands as well. Number of sites, as you can see, one of them, or a couple of them going back for, certainly back to 1990. And you can see some pretty big swings back in the 1990s into early 2000s. And then it stabilizes out a little more. There may be a slight decrease in trends there, but it's pretty flat as far as trends. And you can see the level of the standard, how it's changed over the years, dropping from back in the 1990s to where it was set at 0.08 ppm, effectively 0.084, because that one was based on rounding. And then where it dropped to 0.075 and then down to 0.070 parts per million. You can see that there is, all the levels are below the level of the standard, so it is all in attainment there. And down on the right-hand side, you can see just on an annual basis what the fourth max values are versus the 3-year average, which is the form of the standard in the larger graph. And you can see a lot more variation in the annual data, and that's pretty typical. Looking at the other western slope sites, our longest term record there is an EPA site at the Gothic Monitor, which is north of Crested Butte, Mount Crested Butte. So kind of in the middle of nowhere. And it has dropped over time a bit, but you can still see that the levels there, while everything is below the level of the next, the Gothic site and some of the others there are over 65 ppb for the 3-year average of the fourth max. And so that is still pretty close to the standard of 70 ppb. And it just indicates, that even sites that are out in the middle of nowhere in Colorado can get some high levels of ozone. And so that is a problem that we deal with, this sort of background level of ozone, and there's nothing really much we can do from it. It's coming from out of state, from vegetation sources as well. There's always going to be some knocks around as well from man-made emissions, and but it does create this background level that we don't have a lot above that to control really. And then you can see also on this slide, and especially if you look at the lower right-hand slide on the annual fourth max values, that really high peak back in 2013 at the Rangeley site, which was due to a wintertime inversion in the Uinta Basin that did intrude into Colorado. And it did affect the 3-year averages for a few years there. But we haven't seen much as far as inversions and high values since then. Now, moving on more to the east side of Colorado. So the Colorado Springs area, we do have monitors there, and you can see quite a sort of fluctuation, it's kind of cyclical pattern there. But in the last couple of years, we have gone up over the level of the NACs for the 3-year average in the Colorado Springs area. And a lot of this is really due to the we believe to wildfire influences the past couple of years, especially in 2020. There were a couple of periods there that were definitely very heavily smoke influenced. In 2021, it was a little more debatable, but we still do feel that there was some wildfire influence. So that is an area of concern for the Colorado Springs area. And then if we move on to the Denver area, the North Front Range area, and this is where you can see that is where we do have a lot of exceedances of the level of the standard. We've been in non-attainment, designated non-attainment area for a number of years now. And you can see there's not really a really good trend. Up until about 2018, we might say that there was maybe a slight downward trend, especially at some sites such as Rocky Mountain National Park, which is hovering right around 70 ppb for the 3-year average. but a lot of the other sites, it's very indeterminate. There's no real trend, and the last few years has been an upward trend. A lot of it because of the wildfire influences, but also other influences as well. And there was actually a wintertime inversion event. It happened in spring of this year in the DJ Basin up in northeast Colorado, where we did have high values. It was a very deep inversion that was going on that day, just certain sites within the basin there. And once you got outside of the basin a little more, we didn't see any high levels at those sites. So these data that have been showing a roll through, the slides all show through the end of September. There haven't been any changes to the data since then. So these all stand as is for now. So you can see it is, excuse me, we do have a definite issue with ozone in the North Front Range area. How we deal with it is a question, especially as we do have the high background here in Colorado and in a lot of the other kind of mountain states in the region. So looking at a 3-year summary, and you can see all the sites over, and this is for the North Front Range. Basically all the sites other than the Fort Collins CSU site are over the level of the NACs for the 3-year average. We don't have enough data yet for 2 sites, or sorry, 3 sites, the Black Hawk, the Evergreen, and the Platteville site yet to make a determination. But if you look at the values that we've been seeing here in 2021 and other years when available, they're pretty close. They line up very closely with a lot of the other sites, so we would fully expect that they would be over. They're going to be over the NACs as well. So right now we have 12 sites over the level of NACs. We had 11 previously, and then 5 sites that are actually over the 75 part per billion NACs as well. Looking at the rest of Colorado, just as far as the table goes. There's the 2 sites down in Colorado Springs, but other than that, as I mentioned, all of the other sites are below the level of the NACs, though they are still in the at least above 60 parts per billion, and so and that points to the background that we do have here in Colorado. When we just look at it graphically, you can see where all the sites are, and you can see where our current non-attainment area is defined. In the purple line, and that's where most of our monitoring is. I will note that the boundary will be changing. There was, when EPA came out with reviewed the standards, there was a petition put in by an environmental group to re-review where the boundary is. They felt that it should be actually going up more towards the Colorado-Wyoming border in Weld County. So EPA has just recently made the determination that yes, the boundary will change, but only for the 2015 standard of 75 parts per billion. It will remain as is for the 2008 standard of 75 parts per billion. So it'll change for the 70 part per billion standard, I should say, in northern Weld County, but not for the 75 part per billion standard. So it's just the complexities we have to deal with when dealing with a lot of the different EPA regulations. Well, most of the sites that are on the western slope, a lot of them are run by other agencies. And you can see it does cover certainly the southwest portion of Colorado very well, and some of the other western portions of Colorado. There's a lot of areas of Colorado we don't have any monitoring. It's a concern in some areas. We feel we are going to be adding a site in Pueblo this next year. Weld County has 3 sites that they have established. I don't have any data for them yet, so they're not shown on this. And then the U.S. Forest Service has a number of seasonal sites that they put out every summer across the state in a lot of the areas, the forest areas. So looking at another indicator here, looking at the number of days over the level of the NACs. And you can see that 2021 was definitely different than previous years, a lot of previous years. We had a large increase over the last few years, certainly over, going back, really to the, about 2012 was the last time we had the number of days that we did over 70 parts per billion. If we look at 75 parts per billion, there's more days that we've had in the red bar than we have going back to at least 1995, which is prior to when the data I've got on this graph. And if we look at days above 84, the green bar, we have to go back to 2003 since we've had that many days in the North Front Range over, that many days over that level here. So 2021 was definitely an abnormal year, if we want to put it that way, compared to what we've been seeing over the last few years. And that is definitely a concern. We didn't see a lot of influences, with ozone being a secondary pollutant. We didn't see big changes due to COVID, like we did for some of the other pollutants. But and yes, things have come back here in 21, but 21 was just a very abnormal year compared to recent history. EPA does allow for flagging of exceptional events. So these typically would be for like things that we can't control, such as stratospheric ozone intrusions, when during certain meteorological conditions where we can get ozone from up in the stratosphere being pulled down to ground level, and then influences from wildfire smoke. And wildfire smoke is a little awkward and hard to deal with because we can either get increases or decreases in ozone from wildfire smoke. Typically, if a fire is close by, just the density of the smoke and the lack of time that it's had for any atmospheric reactions, we will often get a decrease in ozone. But when we get a lot of smoke transported in from out of state, we've got long range transport, the smoke has dispersed more, you still get a lot of sunlight coming through for chemical reactions. And also with all the VOCs and the NOx from the smoke itself, from combustion, you have ozone forming in the smoke. So it can go both ways, but EPA does allow for flagging of these events. We always flag events in the EPA's AQS system, the air quality system, that we feel have been influenced whether in some form or another by either stratospheric ozone intrusions or by wildfire smoke. Those are strictly informational flags. If we feel that it's something that we want to do more of a demonstration on, then we can change those flags to request exclusion, and if we do a demonstration and submit it to EPA, if they concur that we've submitted a valid demonstration and that yes, there were a true exceptional event that occurred, EPA will then exclude those data from any calculations towards the looking at whether we're attaining or not with the level of the NACs. They generally don't look at any demonstrations if there's no regulatory impact. For instance, if it's going to either take an area out of attainment or put it back into attainment. If there's no impact there, generally they're not going to look at them. So they take a lot of work to write up. So we do take a close look as to, one, whether it's really justifiable to develop a demonstration, and two, if it's going to make any impact or if it's going to be a waste of our time to do it anyway. So that we have a lot of informational flags that we put into the system just for tracking and for records, but we typically don't do many demonstrations. As far as the last couple of years, there haven't been final decisions made as to whether we're going to be doing any wildfire smoke influence demonstrations at this point. So why was this year so bad? This is an image, a satellite image with smoke, just kind of the smoke plumes on it that was taken back in July of this year. You can see all the gray smoke areas and all the fires which are highlighted in red. A lot of fires, certainly in California, there was the Dixie Fire going on at the time, and then a lot up in Idaho, Montana, and Washington. And you can see we didn't have a lot of smoke influence on this day, just a little bit. But you can see that, while the ozone levels were generally pretty low, or lower, at least by the fires, once you started getting away from those fires, such as in southwest Wyoming, even up into North Dakota there, and certainly down here on the Front Range, we saw some much higher levels of ozone than we typically would have expected for the meteorology that otherwise would have occurred on this day. So yes, the wildfire smoke did have an influence on this day, and certainly in a lot of other areas in the Central Rockies areas, Northern Rockies, that also had high levels that would not have been expected otherwise. Seeing levels up in the 70s, upper 70s, in Southwest Wyoming or Northeast Wyoming like that is just not typical of what's seen in the summer. So, and you can see that we did have wildfire smoke influences, this certainly in 2020 and in 2021, where if you look at the average daily PM2.5 concentrations, the particulate concentrations, they are much higher than we would typically have seen, and that's caused a kind of an increasing trend here. If you look up to through 2019, you wouldn't say there was any real trend going on, but once you add in 2020 and 21, it definitely has an increasing trend there. In 2021, the average daily PM2.5 concentration, with all the wildfire smoke coming in from out of state, it definitely raised that level. And then the other big thing that we track here, and this goes back to, this is work that was originally done by Gabby Pfister at NCAR and Pat Reddy, who is currently working at CDPHE at the time, looking at the average 500 millibar geopotential height. So this is where, where is that 500 millibar pressure? What altitude is it in the atmosphere? And there's been a correlation that's been found where higher ozone tends to correlate quite well with that average 500 millibar height. So as the height goes up, we tend to get more ozone, we get more a deeper mixing layer, and it's more prime for high ozone conditions. And you can see, looking back in 2012, for instance, that was a high where the gray bar, which was the 500 millibar height, it went up and we saw an increase in ozone there. 2014 was low and we had lower ozone. 2018 was a higher ozone year and higher 500 millibar height. And then here in 2021, it's the highest 500 millibar height that's been recorded since the start of the records back in 1940 in the Denver area. And correspondingly, the ozone levels that we saw this summer were some of the worst that we've seen in, going back quite a ways. So yes, there were wildfire smoke influences, but that just made a bad situation even worse. We believe we would have had high ozone even without wildfires in the area, or wildfire smoke coming into the areas. So it was just prime for a bad year for ozone. We do issue ozone action day alerts. We typically look from at the end of May through the end of August as the high ozone season, where we issue alerts. They're issued once a day at 4 p.m. They can either cover an 8-hour period from 4 p.m. to midnight or a whole 24-hour period. And health messaging is the primary focus. And then we also include a pollution prevention message, such as, don't mow your lawn during the middle of the day, refuel your car in the evening, things like that. These are disseminated through emails, websites, message systems, and social media. And we work closely with the Regional Air Quality Council, who is our designated lead planning agency for ozone. And they've got their programs as well. There's some Simple Steps Better Air program, their Mow Down Pollution program, things like that. We also prohibit open and prescribed burning within the non-attainment area when there's an ozone action day in place. We're working on having these action day alerts issued in Spanish as well for this next summer. And we've got a pretty reasonable accuracy rate on these alerts, about 80% accuracy rates for this last summer, so not too bad. As I mentioned, a number of ways that we distribute the action day alerts. If you go onto the top link there, the Request Alerts website, you can sign up for these action day alerts if you haven't already, and then the other areas where they're put out. We also have a close partnership with the National Weather Service Office, and all of our alerts and forecasts are put out on their page as well. So how have the number of alerts gone? This summer, last summer, as you can see, we had 65 alerts that we issued between May 31st and August 31st. And that's the most that we've seen. Obviously, the standard changed in 2015, so we would expect to have more alerts after that, and we did, but if you could look at the graph on the lower right, it just really dramatically increased in 2021. The other thing that we do is advanced ozone forecasts for voluntary emission reduction actions. So this was launched in 2017. We try and issue these voluntary advanced ozone forecasts a few days in advance. We're looking 2 to 4 days ahead to see when we think ozone might be high, and putting out a notification to industry to say, hey, if you can, on these days we're expecting high ozone, please try and reduce some of your actions if at all possible. So for instance, one example might be if a company was planning on doing a well blowdown on that day, to maybe postpone that well blowdown to a following day when ozone levels are not anticipated to be as high, just to reduce the amount of additional emissions that are going into the air shed that could create ozone. So there's 179 subscribers to the email list at the moment. We issued 44 of these advanced forecasts during 2021, and we'll be continuing to do these in future years as well. So where are we with the ozone status? Right now we're classified as a serious ozone area under the 2008 standard and a marginal area under the 2015 standard. We're going to be bumped up to severe in 2022 for the 2008 standard. At that point, there will be more. The major source threshold has been dropping. So typically, what's considered a major source is 100 tons per year of VOC or NOx emissions. When we right now under serious, it's at 50 tons per year. When we go to severe, that'll drop to 25 tons per year. So there will be a lot more major sources looked at for potential controls. And then under the marginal standard of the 2015 standard, we're also going to get bumped up in 2022, either to a moderate area is the next that we would go up to there. The rest of the state is attainment. Vehicles and oil and gas development are the two largest sources that we see of ozone precursors. As I mentioned, the RAC is the designated lead planning agency, and they have a number of different programs as well to help reduce ozone levels you can see listed here. So as far as historic and more recent emissions reduction strategies, historically we focused on stationary sources such as power plants, oil and gas. Power plants, a lot of those are shutting down, so they're not quite as much of an issue as they used to be. And then more recently, we've expanded to consumer products, low VOC paints, for instance, and other low VOC products for as well, other products. We continue focusing on stationary sources such as oil and gas. And then for transportation, the federal government really sets the emission standards for vehicles, so we're a little more limited there. But what we have done is we've instituted LEV and ZEV requirements, low emission vehicle and zero emission vehicle requirements. So there's now a certain percentage of electric vehicles that have to be sold, for instance. Looking at the trends, as you notice, the ozone design values, the 3-year averages, that, as I mentioned, up until at least up 2019, were not too much change in those. You can see those in the dots there, the orange dots. But with our emission control strategies and regulations, you can see that the daily VOC emissions and daily NOx emissions in the blue and red lines have dropped significantly over the years. Really dramatic changes there. And that's in spite of both the oil and gas production, population, and the daily vehicle miles traveled increasing. So yes, we are decreasing the ozone precursor emissions in the area. As I mentioned, since we do have a high background, it doesn't quite reflect as much as you would expect in the overall ozone values, unfortunately, but we are decreasing emissions significantly. And so that is a good thing, whatever the case. Just comparing, this is for VOCs, looking at 2016 emission inventories and then projected emissions in 2023. This is for our ozone state implementation plan. You can see that biogenic is the big portion there. It's 39% in 2016. Since we're reducing emissions, that actually jumps up to 49% in 2023, and a lot of the others decrease. The oil and gas tanks, for instance, the purplish goes from 22% in 2016 and drops to about 7% with all the controls that are planned in 2023. So there are some big changes there that are looked at, and you can see the overall VOCs are decreasing from 673 tons per day down to 537 tons per day. For NOx, we do also have a decrease in the overall tons per day, and the big change there, you can see the non-EGU point sources, the EGU point sources, the blue, goes from 15%, kind of the upper blue section goes from 15% down to quite a bit less, about 7%, I think it is, in 2023. And a lot of that's with, that really is with the power plants closing. You can see that the oil and gas area sources, the kind of the blue on the lower right, that actually increases as far as a percent amount. As oil and gas increases and combustion increases there, but the on-road decreases, which is nice. So we're definitely seeing shifts in what are the more important sources versus not. So looking just as a general overall contribution. Light-duty vehicles, well, let me start at the bottom actually. Background concentrations, you can see, contributes about 47 ppb of ozone to all of this. And then the other two big ones are at the top, which are light-duty vehicles and oil and gas area sources, at a little over 5% for both of those. And then you get down into other categories that are lower than that. So this gives us an idea of where do we need to focus future emission controls regulations. What's going to make the most bang for the buck. And with that, I'll take any questions.
Thank you, Mr. Pierce, for the overview and for being with us today. Really very good information. Appreciate the overview. Do commissioners have questions? Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Mr. Pierce, for sharing this today. I really appreciate you presenting. And I think that it's easy to kind of get lost in the technicalities of things. And so I was wondering if I could ask kind of some higher level questions and see if you have some answers. So, in order to get into attainment, right, we have a state implementation plan, which is all the strategies we're going to do by sector to reduce the pollutants that are precursors that cause ozone. So what is the timing of this next state implementation plan that is put together by CDPHE? And what will be the role for I'm just wondering how much we think oil and gas is going to have to further reduce precursors and what strategies might be considered. And I know the RAC is involved in that. Sorry, this is a string of questions that I hope will all come together. And then what do you see or foresee the role of the commissioners and COGCC to help make sure that we are supportive in helping in the non-attainment area, for example, and reaching those goals, either from a regulatory or policy perspective? I'll start there.
Okay, sure, Commissioner McGowan. So yeah, as I mentioned, it's not an easy one. And it really depends part of the problem is it depends where you are in the Front Range as to whether you're considered NOx limited or VOC limited. So oil and gas actually has a little more influence, for instance, up in Fort Collins on ozone levels. Motor vehicles and as well as oil and gas have more of an influence in the Denver area. So that makes it difficult, but we are working on the next round of SIP modeling that'll needs to go to EPA. I'm trying to remember just when the date is. And then when we get, we'll have to submit some information certainly to EPA in the next, I believe it's in 2023 that we'll be submitting the next round of SIPs to them. I'll need to check on that for sure. And it may be worth getting a presentation from our planning policy and planning group for the COGCC. That might be a useful presentation as well. But as far as strategies that are being developed, certainly there's more going on with oil and gas, looking at the pneumatics. I think there's going to be more coming up, looking at some of the other types of sources such as blowdowns. Wastewater injection is certainly being looked at with our new mobile van from driving by some of the wastewater injection facilities. We are seeing some high concentrations there. So we have a number of conversations that our oil and gas group unit has going on with the wastewater facilities and those companies, and looking at trying to determine really at the moment where exactly are those emissions coming from, and what can be done to control them. So there will be additional regulations there, I think, a little more, and I think that's an area where nobody really knew exactly what was coming off, so the permits are not quite written correctly to account for those. So those are some of the areas where I think that work will happen in the future. I think there will be probably more work on consumer products as well, and certainly there's a closer look going on for off-road vehicles, so construction equipment, lawn equipment, things like that as well. So how can the Commission help? I think certainly being supportive of any regs that are presented to the Air Quality Control Commission. I think there'll be continued, I'd like to see continued collaborations between the agencies as well I think that COGCC probably has information that we don't at CDPHE on a general basis, that we can share information back and forth to determine where other sources of emissions may be occurring.
Thank you. And Commissioner Hackett has done a good job, I think, in some of our permit review hearings, trying to encourage some of our operators to look at going tankless. Electrification, to get at your point of construction equipment, might be a big source for ozone precursors, those types of points. And so just to put it in context, I think that's putting the points together. Maybe that's why some of the comments are coming from CDPHE. I'm wondering, I think that the Erwin Martinez Fund funded some flyover activities this summer, and I'm wondering if that data is showing anything, and or if it's going to influence where we see certain types of pollutants coming from. And maybe the flyover doesn't really get at any VOC, so I might be heading up the wrong tree. So if you could help me out there.
Sure, Commissioner McGowan. Yes, with the Erwin Martinez Fund, we have a number of projects there. One is the what we're calling our Moose, our new mobile van, mobile optical sensing van. And with that, like I said, we've been driving by some of the facilities, and we've certainly seen the high levels at the wastewater injection facilities. And then the other, as far as the aerial surveys, yes, there were 2 rounds done. There was an initial round done in July, and that did show there were they did determine a number of sources there. They found basically 3 sorts of, and that was focused really on methane. What was seen, it was kind of a mix of 3 major sources. About 40% of what was noted was from oil and gas sources. About 40% was from CAFOs, from agriculture, confined animal feeding operations, the feedlots. And then about 20% roughly of the total emissions was from landfills. Then we had more of the main aerial flyovers work that was done in the end of September of this year. And that's not only included the same group doing the methane flyovers from the University of Arizona, but also had aircraft from University of Maryland, scientific aviation as well, and then also ground-based efforts. And things had shifted a little bit. We think probably it was a little cooler temperatures, so we weren't seeing as much emissions from the CAFOs. So it was more like on the order of about 50%, 50 to 60% of the emissions that we're seeing were from oil and gas, of the methane emissions, and then 20 to 30% from the CAFOs and about 20% still from landfills as far as the overall split. Now the data from the July flyovers are available. Carbonmapper.org is the website. And I can share these data, show you on these data as well. Let me just share my screen here. So this is the Carbon Mapper website, and for instance, the base map is not showing up for some reason. Let me just switch to this one. So these are all the flights that Riley Duran at the University of Arizona has done. He works closely with NASA JPL. You can see there's been a lot of flights down in the Permian Basin in Texas. He's done work in the San Juan Basin as well. But these are the ones from the DJ Basin that were done in July. So when you zoom in on these, let's just pick, for instance, these here, you'll see them show up. You can see that, for instance, if we zoom on this one, where the plumes are that he was seeing. This is obviously off a CAFO here. But you can see more information on the left-hand side. You can click on either on the dot or itself or on details over on the left, and you get much more detail on it. So their estimated emissions of about a little over 500 kilograms per hour of methane. So you can get a lot of information on these, but we did see there was a pipeline that was found to have been broken that they did detect, and that has since been fixed. That was one of the big emission points that was seen. And then there was also I believe it was a fracking rig that was working at one site, and apparently it was old equipment that they were using, and we were seeing some high emissions from that. And that company, to my knowledge, was planning on replacing that equipment in the near future anyway, so that should hopefully be resolved going forward. But so yes, all of the data from the initial round of flyovers are on here. It's probably in early January. The second round from September will be posted on this same website.
Thank you. So informative. So last question. I don't suppose that there's been any kind of cross-reference to emissions and an age of a well or the type of well that it is?
No, there hasn't been at this point.
Okay. Thank you, Mr. Pierce.
You're welcome.
Great questions. Others with questions? Commissioner Messner?
Thank you, Mr. Chair. Thank you, Mr. Pierce. Great information. Appreciate that. As you may or may not know, I was a previous county commissioner in Gunnison County, and I'm not sure that the constituents in Gunnison County think that they live in the middle of nowhere.
My apologies on that.
But anyway, I appreciate the Gothic Research Center and the information that they've provided all these years, no question. But that led me to my initial question, and the background levels. So you've got certain background levels in the Gothic area or different parts of the Western Slope that seem relatively consistent. And maybe you said this and I missed it, but what constitutes like what creates those background levels? Like how do you get that background level, and then how do you determine what's causing, I guess, the difference between kind of a standard background level and some of the non-attainment we're seeing in other parts of the state?
So Commissioner Messner, thank you for your question. Background ozone is a combination of ozone coming in from out of state, a little bit even from international transport, and then also just natural emissions. There are some natural NOx, but also the biogenic VOCs, those reactions to create ozone. So it's anything that's really coming in from out of state or is formed from more natural sources that we can't control. There's been a number of studies done. EPA has done modeling across the US, and the whole kind of Rockies and even more of the western states as well tend to have much more of a natural background ozone level. You don't see it as much on the East Coast, for instance. There's only a few parts per billion there, but a lot of the contribution, what's natural versus, or what's background versus what's locally produced. There's not an easy way to determine it monitoring wise. It's really done more on the modeling basis. So a lot of it's either projected or done after the fact. If you're looking at specific days, you have to model all the emissions coming in and versus what's, really you have to look at what's, you model what is produced from local sources and then compare that to what you was actually seen on monitoring and look at that additional amount, which would be considered more of your background level. It's not easy to determine really, and that's part of the problem. But EPA modeling has shown anywhere, typically from their modeling, they see anywhere from 40 to 55 parts per billion on any given high ozone day is likely from, in this area is likely from background sources.
Okay, and I know you talked a little bit about this, but I maybe am not fully understanding it. But you know, we had this abnormal spike in 2021, and I think some of that was being associated to wildfires, particularly wildfires that are out of state and that are producing some level of emissions at a very high altitude. I've got to assume that we've had similar situations to this, you know, over the years. Why not an associated or similar spike in those particular situations compared to this year? I guess I'm kind of curious about that. And then understanding that in some of the recent history, there's been some pretty significant wildfires, you know, in Colorado. And I assume that we're not seeing major associated spikes there because it didn't have time to get up to a certain altitude. Is that, am I grasping it at all, or?
Sure, Commissioner Messner. You are correct on a lot of it. So wildfire intensity has been, so in 2021, we do feel there was some wildfire influence to the ozone, yes, for sure. And then we think probably the more important factor was just the fact when we're seeing that high of a 500 millibar height, that just the meteorological conditions were what really played into the significant increases in ozone this last summer. So we think it would have been a bad summer without wildfires. But wildfires have been increasing in frequency and intensity over the last 5 to 10 years for sure. 2018 was pretty bad on wildfires. 2019 not so much, but then 2020 and 21, just across the whole western U.S. we've seen a lot more wildfires. And it is that long-range smoke where we see there's much more potential for creating some ozone in that smoke. Not necessarily that it gets up to higher altitude, but it's really what's still down here, what gets transported and still remains down in the lower atmosphere. And we see it, you know, obviously as visually here where we can see it, we can smell it at ground level. But when it's had that long range transport, it's had the time for the atmospheric reactions to occur to create ozone. But it's not as dense as when you get a local fire to block the sunlight either.
Okay. And then it appears in some of the data and statistics that you've provided that a significant portion of the emissions is coming from a category called oil and gas area. And is that just, maybe you could give me a clearer definition of what an oil and gas area is. I get the oil and gas tanks, I get the point source oil and gas, but I'm a little gray on what an oil and gas area is.
Sure. So the way it works, at least in the permitting side for stationary sources, is, excuse me, you can either have points, and like you said, whether it's a known stack, you know, for instance, a stack of a flare, a tank, something like that, or where it's a little more kind of subnebulous or dispersed. There may be lots of little points, or there may be a lot of very small sources that you don't individually categorize. For instance, for gas stations, there's a lot of gas stations. They don't individually put out necessarily a lot of emissions, but they're just kind of aggregated overall in an area. So that's kind of considered an area source. So with oil and gas, for instance, all the valves, the pneumatics, you know, those could be considered an area source for oil and gas.
Okay. Well, I mean, again, appreciate the information. I would, and I think you recommended this or offered this, but I would be interested in the policy and planning group giving us a presentation. I think that would be super helpful. And also, as one commissioner, as we review oil and gas development plans and different applications, the consultation with CDPHE is a really important piece to me. And I know it's only required in certain scenarios in oil and gas development plans and other pieces of our review process, but particularly in the non-attainment area. But generally speaking, I would highly encourage CDPHE review, consultation, and comments on every application that comes in front of us, because I think it's incredibly important that we have that information and that communication is happening between COGCC and CDPHE as we look at these different situations. So thanks for your presentation today.
You're welcome.
Mm-hmm.
Thank you, Commissioner Messner. Any further questions? Commissioner Hackett.
Thank you, Mr. Chair. And I actually had a question for you, Commissioner Messner. So you mentioned you did want a presentation from the Planning and Policy Program within the Air Pollution Control Division, and just wanted to make sure I'm clear on kind of the scope or topic there. Are you kind of wanting a state implementation plan, development 101 type of training, and kind of a preview of the SIP that they plan on submitting for their most recent ozone efforts? Is that kind of what you're shooting for?
Yeah, that would be perfect for me. Yeah.
Okay, and then Gordon, just so you're aware, I will go ahead and work with the planning and policy folks to go ahead and get that scheduled up, so you are off the hook for that one.
Okay, sounds good. And we should make sure that Mike Silverstein is included in that for the RAC.
Excellent, thank you.
Commissioner Hackett. Further questions for Mr. Pierce? All right, seeing none, thank you, Mr. Pierce, so much for the excellent presentation and the information that you provided to us, as well as the rapport back and forth with the commissioners. We really appreciate it.
You're welcome. Thank you for having me.
All right. We will move forward with our agenda. Next is consideration of docket number 1904-00289. But before we do that, let's take a 10-minute break. Let's plan on coming back at 10:25. And Ms. Amaro and Ms. Larson, if you could tee up the parties for us at 10:25, we would appreciate it. All right, welcome back, everybody, to the Colorado Oil and Gas Conservation Commission meeting. We will now take up matter 1904-00289. And thank you, AG Davenport, for appearing. You read my mind. Was wondering if you might set the stage for next steps on our deliberations on this matter. We had started deliberations. We then paused deliberations, and we were going to allow Ms. Merlin, one of the party's attorneys, an opportunity to get up to speed. And so here we are to restart deliberations today.
Thank you, Chair. Good morning, Commissioners. Commissioners, as you're obviously aware, the Commission did begin deliberations on this matter a week ago and then continued it. I believe, though happy to be corrected by any of the Commissioners, that the Commission has deliberated on many of the issues presented in this matter. And at least in my view, there's really one issue with perhaps sub-issues within it, and that is these 8 or 11 people, I'm not exactly sure what the number is, and the offers to lease or participate, were they sent or received by those folks? And I think that is the final issue remaining for the Commission to resolve in the course of deliberations. Though, again, if Commissioners believe that there are other issues, then we'll need to discuss those as well.
Thank you, A.G. Davenport. I tend to agree, but I think what I'd like to do to start out today is to give Ms. Merlin an opportunity to be heard. Ms. Merlin, I see you're with us. Can you let me know, I guess first off, were you, I know you were apprised as to the video and audio. Were you able to go back and listen into the matters that were discussed with Mr. Pershala, so that you are, I guess I'm just trying to make sure you're up to speed and ready and able to present whatever you would like to present on behalf of your client today.
Thank you, Chair Robbins. Yes, I did have a chance to review the video. I will note that while the Commission began deliberations last week, they also reopened the record, and I believe that the record remains open. I have a short statement that I prepared to address some of the prejudice that I believe was created by the ex parte nature of the proceedings that occurred last week, if you would allow me to read it.
Yes, I will allow that. You are recognized.
Thank you. So Commissioners, I listened to the testimony from last week's hearing, and at the outset, I heard Chair Robbins acknowledge that I was unable to be present and that I had given my approval for the Commission to deliberate this matter in my absence. So I was quite surprised that a short while into deliberations, the Commission moved to reopen the record to ask questions of the applicant's counsel, accept direct testimony, accept new evidence, and even question the applicant's witness, despite my conspicuous and acknowledged absence and lack of consent for such ex parte proceedings. The testimony that was received seemed to move this Commission to reach new conclusions about the facts of this matter. Instead of 11 owners without offers to lease, now there are 9 or maybe 8. And Mr. Pershala was allowed to testify regarding post office pickups. For the majority of these owners, even though that appeared nowhere in the record and is independently unverifiable due to the passage of time. Then Mr. Davenport allowed this to happen, and in fact that you advised you that you should make a motion to reopen the record without mention of the ex parte rule is beyond dismaying. I'm extremely concerned about last week's proceedings because I believe that there's actual prejudice, but beyond that, the appearance of bias is overwhelming. After being contacted by text message by a member of the public informing me that the record was being reopened, I was present and asking via the chat to be admitted to the proceedings for almost 10 minutes before I was acknowledged at all, the entirety of which the Commission continued to ask questions and take testimony. I listened to this deliberation and the great weight that was given to the burden on operators of locating mineral owners in densely populated suburban neighborhoods where there might be hundreds of separate owners. It was suggested that it would kill the application to require proof of receipt from extraction. Mr. Salazar's protested hearing suffered even more deficiency in evidence. Extraction disclosed no tracking receipts to either Mr. Salazar or to you. And I would ask that you consider the door that's being opened. The applicant is already giving you 100% of the information that you rely on to hear these matters. They tell you who the mineral owners are, and you rely on them. They tell you who is already subject to a valid lease. And even if that lease was from 1904, you would have to believe them if they told you it was still valid. But while you rely on the evidence that they give you, there's little to no independent inquiry into matters on which they have failed to provide any evidence. Extraction told you about owners who didn't receive their mail, which contained the lease offers, but they didn't tell you about owners like Natalie Quarantino, who is listed as an unleased mineral owner, but for whom no lease offer or tracking information was disclosed. Nor did they tell you how easy she is defined through a simple Google search. I spoke to her for a second time on Monday. Extraction saves money by force pooling people. They face less public opposition to their project when neighbors don't know what is about to happen. It's in the interest of the applicant for owners to refuse offers. We've seen landmen such as Mr. Rayburn go door to door of mineral owners to talk them into leasing, where leasing is actually the goal. But now with suburban tracts where incentive payments and community opposition are too good reason to avoid conspicuous lease offers, the COGCC is poised to greenlight this practice of least acceptable diligence that finds even where extraction has actual knowledge of non-receipt, they have no obligation to perform any additional diligence, not even a Google search. There were hypotheticals from the commission about whether the commission should deny a pooling application if extraction has used all reasonable diligence to locate the mineral owners, but extraction had actual notice of non-receipt and did nothing about it, which is the evidence that you have before you today. This pooling application could just as easily be held over until extraction returned with evidence of receipt, or at least evidence of some reasonable threshold level of diligence with regard to the offers. It is not a matter of kill it or approve it immediately as submitted. Extraction can't afford for you to deny this pooling application because they have already commenced well completions and putting wells into production. But please consider that you have alternatives beyond rubber stamping applications submitted with insufficient evidence that does not involve watering down these rules. And that is the statement that I have to read for you today. Thank you for allowing me to address you.
Thank you, Ms. Merlin, for your statement. It is made a part of the record. With that, I think we now turn it back over to the remaining 4 commissioners for continued deliberation. I would note that we had the ability to reopen the record if we so desired. I note that from notices and emails between hearings manager Larson and Ms. Merlin that I believe that the record was clear on that front. I also would note that, Ms. Merlin, thank you very much, but that we stopped deliberating when you appeared, and we gave you an opportunity to fully get back informed, and we gave you the opportunity to participate again today. So I believe that we have afforded Ms. Merlin and her clients all due process, and we now can move forward with deliberation amongst ourselves. Mr. Davenport, do you have anything further before we move forward with deliberation?
No, Mr. Chair, I don't. As I noted before, the commission needs to resolve, of course, any other issues outstanding in its mind today during deliberations, including the question of the lease offers from last deliberations. I'm not sure what else the commission thinks is outstanding.
Okay.
But that's what I saw as outstanding.
Okay, thank you. And I think that the commission has already ruled that Wild Earth Guardians does not have standing to bring forward a request to dismiss the whole thing as a result of others that are not its clients that may or may not have received notice. I think we've been pretty clear on that front. And so I think where we end up at this point is there was the reading into the record by Mr. Prashala of, I think it was 9 individuals, or not individuals, but 9 parties that received notice, but that did not, I had, oh, here it is. Here's my information. That received the notice, and as to one, it said in transit, and as to all the others, it said needs to pick up at USPS. So my articulation of that is that the notice was delivered. There was probably a little note on the front door. You need to pick it up at the Postal Service, and then that did not happen. I still have a question as to the Hoskin notice, Hosking. That's John and Julie Hoskin as joint tenants, in that it said in transit. But I also believe that there perhaps was some testimony that that group of 2 individuals ultimately were leased. Do other commissioners have recollection of that, or do we want to bring Mr. Prashala back to clarify the record on that point? Commissioner Gonzalez.
Thanks, Chair. Yeah, to that specific point, my notes reflect the same, that the Hoskings, I think they were in Arizona, showed a status of mail in transit. So I think we're aligned there. And I think it was Mr. Rayburn's testimony, as I recall, and as I have in my notes, that those owners were leased by another lessee, and that that Extraction has plans to seek voluntary pooling of that lease with the lessee.
Okay. Okay, so that then leaves the other 8 parties that received notice and with the evidence that they need to pick it up at the U.S. Postal Service. And I think the question for the commission is whether we believe that is valid or sufficient notice under the statute and our rules at the time, effective time for this proceeding. I am of the opinion that that is sufficient in terms of notice and receipt. I do not believe that there needs to be a further showing of actual someone goes and picks something up at the Postal Service if they knew that they had the opportunity to pick it up. But I'm open to discussion along these ideas or to hear from my fellow commissioners. Commissioner Gonzalez.
Thanks, Chair, again. I'm in agreement with you. You know, I spent a lot of time thinking about what this particular element of receipt means in preparation of the hearing last week. And for me, the conclusion that I reached was that it means receipt at the last known address. And for me, I think that delivery that occurs and then is not accepted and is taken to the post office through certified mail. To me, I do believe that meets that meets that element of receipt at the last known address. As the Hoskings with the status of mail in transit, I would not be comfortable force pulling them, and I do not believe that the elements as to that owner have been met. But as to the rest of them, the other 8, I believe, or the other 9, I can't recall what the exact number was, really all but the Hoskings, I believe that the burden has been met and the elements have been proven by Extraction for this pooling matter. I also kind of want to address that, you know, we don't get a chance to look at these with such a critical eye as they come through the consent agenda. And I think this is one unique situation where we had an opportunity, you know, to look under the hood a little bit. And as we did, you know, it was appropriate for us and really our obligation to really explore all these elements. And I think that we did a good job, you know, giving some hard thought as to what the rules really mean. And so, you know, I think we did the right thing, even though it wasn't necessarily as clean of an elemental, I guess, case as could have been put on by Extraction. I think that next time these come before us, hopefully those elements come through in a clearer way that allows us to make that determination strictly based on the application of the rule. So that's kind of where I stand on it.
You were muted, Mr. Chair. I couldn't tell if I was.
Thank you. I recognize you. Sorry.
Okay.
I'm unmuting myself.
So, I mean, there's a couple things I wanted to bring up here. While I think in this case, we certainly shared some thoughts during deliberation and initially, began deliberations. I don't think that we've clearly taken any kind of formal action on any motion to dismiss or motion for summary judgment. And so I don't know if that's something that we need to do in a formal way or not, because I think that up until this point, it was just some conversation and some deliberation. So there's that. I tend to agree that it's more likely than not that the particular individuals did receive, or at least there was a real attempt to deliver the leases, and so I'm pretty comfortable with the information that has been provided as far as whether or not there was a reasonable attempt to deliver these particular leases to the individuals that were named. I still am struggling with the fact that in testimony there was 11 parties that were indicated initially, and now we're at a lesser number. And so I'm not sure if it's possible or not in this particular situation, but if it is found that there are additional situations where there are individuals that either there was evidence that they didn't receive leases, or there was evidence that the leases were in transit, or that they weren't actually delivered, that they not able to be pooled, force pooled in these particular situations. And I also agree with Commissioner Gonzalez that the individual that has the receipt that indicates that it's in transit, it would not be appropriate to force pool them in this particular situation. I think we've made it clear through deliberations that there has to be, particularly in the delivering of leases, some clear evidence that's provided by operators that individuals, mineral owners, have received leases or have been delivered leases. And so I certainly hope that folks are hearing that there has to be evidence that is provided, and it can't just be put a stamp on an envelope and hope that it gets there. So I think that's where I stand right now.
Thank you, Commissioner Messner. Commissioner McGowan, you're the last remaining commissioner. Did you have any thoughts that you wanted to add?
I thank you, Mr. Chair. I don't disagree with my fellow commissioners. I would like to maybe address some comments that I heard from Ms. Merlin earlier, and just make sure that I am understanding our own rules. Pooling and approval of pooling is not required prior to an operator drilling or starting to drill. I just want to make sure that I'm correct about that, because I feel like she's implying that us stopping any sort of pooling would have an effect on any activities that are at this site.
Thank you, Davenport. I think I know the answer, but I'd like to hear it from you.
Yes, thank you, Chair. Thank you, Commissioner McGowan. That's accurate. From the Commission's perspective, the only thing that is required, that we require for an operator, this agency requires for an operator to drill a well, is spacing and the permits. So the various forms, current rules 2A, 2B, 2C, and Form 2s, as well as a spacing unit. This has obviously been combined as an OGDP in our most recent cases. So yes, it's accurate to say that our regulations and the Act itself do not require an approved pooling application for an operator to build surface locations or drill wells.
Thank you. And I just want to clarify also that if we believe the operator has in good faith reached out to the folks that own mineral rights at their last known address in a way that they can prove to us that there was receipt, there's a potential that there might be mineral owners out there that still have yet to be identified. And that would not stop a pooling application. It would simply mean that later on, if we were to discover one of those mineral owners, there is still an opportunity for that person to participate.
Thank you. Yes, so the Commission's rules certainly allow for pooling, and the orders themselves allow for a pooling order previously entered to be modified by a person who has, through application by a person who has standing. And also our rules provide a general ability for anyone who is impacted or affected and aggrieved by a commission action to bring an application before the commission to modify that prior action. So there are options to modify previously entered orders by someone who has standing, in other words, is impacted by that order.
Thank you. And then for my own clarification, I believe that to the other, I think there's another piece to this, which we may have already discussed, but I just want to make sure that we did, and that for myself, I put it to rest. The argument about how the offers may have not been fair or made in good faith, that in this instance, Extraction also offered to negotiate with these folks as well. Can someone just clarify for me? Sorry. This is why I like to do things all at the same time, because then I feel like I'm forgetting things.
Oh, and I think we all are appreciative of trying not to be disjointed as we undertake deliberations in this matter. That is my recollection of the testimony as well, Commissioner McGowan, is that with regard to many of the elements of the offers in which there was concern raised, that there was either the opportunity to withdraw the issue entirely or the opportunity to, call each other and have a chance for a dialogue or a discussion on the issue, which opportunity was not taken up by the petitioners. Other commissioners with thoughts as to this point in terms of your recollection of the issues? Commissioner Gonzalez, I see you on mute.
I have the same recollection.
Thank you.
Further questions, thoughts, discussions from commissioners? Does any commissioner desire to make a motion? Commissioner Gonzalez unmuted first. Commissioner Messner raised his hand first. I'll let you two fight it out.
I'll let Commissioner Messner make his comment. I think he had something to say.
I just have a question, not a motion. But I assume that the motion is going to have to include any mineral owners that would not be force pooled in this particular situation. And so I guess that's my question. And so have we come to consensus or a conclusion as to if there are mineral owners that are not going to be force pooled, and if so, who is that? And then two, do we need to take any action on, and I think it was just a motion to dismiss, but it could have been a motion for summary judgment. I can't remember right now. Prior to making a motion on this, or is it just inherent that once we make a motion on this and make a decision that would negate the need to have a formal action on previous motion?
AG Davenport.
Thank you. Yes, I think, so to answer the second question first, I think it would be implied were the commission to approve the application, that the motion to dismiss is also denied. Technically, the hearing officer denied the motion to dismiss, and it was brought back before the commission. And I believe the commission's decision at the beginning of this matter was to allow the parties to present their arguments and to make a decision on all issues at the end of this matter. So the written order can clarify exactly where that stands, but I do believe it would be implicit in the commission's granting of the application that the motion to dismiss is denied. If a commissioner would like to make that clear in their motion, that there's no problem with that either. In regard to your first question, if there's any particular person that the commission believes should not be subject to the non-consent status, then I believe that would be important to include in a motion as well, given that extraction does have a list of persons that they wish to apply the non-consent status to. And one of those people, I believe, is the hosking folks that we discussed previously. I think the commissioners have already discussed that those folks, I don't believe that they will be subject to non-consent as they have been leased, is the evidence before the commission. Commissioner Regal, I'm sorry.
Thank you, Mr. Davenport. Question on that: if we approve the pooling order as to all owners with the exception of the Hoskings, do we have to take a separate action or make a separate comment as to their non-consent status, or by virtue of them not being included in our approval of a hearing of the pooling application, does that just mean that they're not going to be pooled and they're not going to have that non-consent status because of A?
AG Davenport.
Thank you. The commission's approval of the pooling application pools the unit, including the Hoskings. The question is whether or not they are subject to the non-consent status. I believe, though certainly happen to be corrected by Extractions Council or one of the commissioners, that given the leased status of the Hoskings, they're no longer subject to the non-consent status. Sorry,
Mr. Davenport, let me challenge you on one thing really quick to make sure that I have my understanding correct. Is the pooling pools leases and unleased owners into a unit, and so we may pool a unit, but there may still be owners in that unit that are not pooled to that unit. And so that's kind of what I was getting at, is if the Hoskings aren't pooled to this unit, is that a separate determination other than kind of our determination or our application of a non-consent status?
The actual pooling is the pooling of the unit is a separate question from necessarily providing non-consent penalties to people. Did that answer your question?
Yes, and I suppose it does. Let me clarify that one more time, is that if we pool the unit, we're just saying that, hey, this will be the pooled unit, and then we are applying that pooling to particular leases and unleased owners as identified on the application. And that means we're applying a non-consent status to those.
That's correct.
Okay.
All right. With those clarifications, do we have direction or a motion from commission?
Mr. Chair, I'll attempt at making a motion here. I will move to approve the pooling application for the United unit under docket number 190400289, and to apply the non-consent and cost recovery as requested by Extraction in their application as to all owners except for the Hoskings owners, as identified in the record prior to these deliberations and I guess during these deliberations as well.
Great. Thank you, Commissioner
Second.
Gonzalez. We have a motion and a second. Is there further discussion? All right, seeing no further discussion, all those in favor signify by saying aye.
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 Any opposed? Motion carries 4-0. Thank you, commissioners, for that.
Mr. Chair.
Yeah, AG
Uh,
Davenport. Go ahead.
Thank you. And just to clarify as well, in case there's any question in regard to the record, the commission's motion and approval of the application also closes the record in this regard.
Yes, it does. Anything further procedurally, AG Davenport?
No, thank you.
That concludes our agenda items for today, my fellow commissioners. Does anybody else have anything for us? All right. I would note procedurally that we did have on our calendar a Friday work session, so to speak, and I believe we're going to cancel that meeting. We do not have anything pressing. We're all going to jump back into financial assurances, which were submitted late last night. And I would also note for the record that anyone that is desirous of looking at the most recent developments on financial assurances, that is indeed up to date on our website, and you can access it from the homepage. Click on the first docket that you see there, and you'll get to all things financial assurances. And at the bottom there, you'll see a red line as to the previous version draft, as well as a clean. And we look forward to hearing from all of our stakeholders on that front. Commissioner Messner?
Thank you, Mr. Chair. Just I'm still not seeing it on the website on my computer. And so I don't know as it's actually, and I'm refreshing and caches and stuff. So
I saw it during the break. I went and for some reason my computer was able to let me see it. Ms. Larson, I see has zoomed in. Do you want to weigh in?
Yeah, I would just offer, and it sounds like Commissioner Mesner, you may have already done this, but if you do clear your cache, if you're going through Google Chrome and clear your cache, that should populate. I had to do that, and it did populate on my end once I did that.
And I just did it once again, and it's right at the top. It says staff's revised draft financial assurances rule, and there's a click here button, which then takes folks to the financial assurance rulemaking page, and the December 7th red lines are kind of toward the bottom. So maybe it's the significance of a state-issued computer, Commissioner Messner.
yeah, it could be. I mean, I cleared cache and it's not there for me. Okay. We'll see. Yeah.
All right. Seeing no further suggestions, I guess I'm looking for a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
We are adjourned. Thank you, everybody. Take care, and we will see you soon.